Number 69, matter of Adirondack Wild, Friends of the Forest Preserve versus New York State Adirondack Park Agency. Counsel.
Good morning. May it please the court. My name is Christopher Amato. I represent the petitioner's appellants in this matter. With the court's permission, I'd like to reserve 2 minutes of my time for rebuttal.
Of course, sir.
This is a case of first impression arising under New York's Wild, Scenic, and Recreational River System Act. At issue here is respondents' decision to open a wild river corridor located in the Adirondack Park on Forest Preserve lands to public motor vehicle use, despite the fact that both the Rivers Act itself and the Adirondack Park State Land Master Plan specifically prohibit the use of motor vehicles in wild river areas.
So to rule in your favor, do we have to determine that the master plan is the equivalent of a legislative enactment?
No, Your Honor, because there is, within the Rivers Act itself, a specific prohibition against the use of motorized vehicles in wild river areas. And right now, as things stand, there's a conflict between respondents' attempt to use the existing use provision to allow such use to occur in a wild river area and the Act's specific prohibition against motor vehicle use in wild river areas.
Help me understand why we should not defer to the APA's conclusion that there is no conflict, that this is permitted, where they drafted the master plan, they expressly reserve the right to interpret it. They work with the DEC to do the plan for this area, and they approve it. Why doesn't that sort of end the inquiry there?
Well, because, Your Honor, this is a matter of pure statutory interpretation. The conflicts...
Well, let me just interrupt you for 1 second, and I apologize for doing that. But the statute would be the environmental conservation law. I'm not asking you, my question isn't about whether we should defer to the DEC about interpreting that law. I guess my question is more directed as the APA says that there's no conflict with its master plan and that determination.
But that determination lacks a rational basis because the Rivers Act specifically requires that in the event of a conflict between the multiple management restrictions that apply to river areas that are located on forest preserve lands, the more restrictive provision must apply. Here, the more restrictive provision, as it exists in both the Rivers Act itself and in the master plan, specifically prohibit the use of motor vehicles in wild river areas.
Why doesn't a plain reading of the master plan, where it says, I think the words are, DEC has exclusive jurisdiction and authority independent of the master plan, why doesn't that avoid the conflict issue?
Because the conflict is not only between the existing use provision in the Rivers Act and the master plan. There's a conflict between the existing use provision and the Rivers Act itself. The Rivers Act specifically prohibits the use of motor vehicles in wild river areas, just like the master plan does. And the Rivers Act also has the conflicts provision, which specifically mandates that in the event of a conflict between different management prescriptions for river areas, the more restrictive one is to apply.
But isn't there a notwithstanding anything else in this Act provision in the continuing or existing use provision itself? Wouldn't that seem to override anything else in the Rivers Act?
No, because it doesn't state notwithstanding anything else in this Act. It says nothing, notwithstanding anything contained herein. And it's clearly, that provision is clearly referring to subdivisions A, B, and C within that provision, which set forth all of the use restrictions and development restrictions that apply in different river areas.
What is your support for that interpretation as opposed to the interpretation that Judge Garcia just suggested?
Well, there are several portions of the Rivers Act in which the legislature intended to apply to refer to the entire act. And in those cases, the legislature used this title.
But it's not consistent, is it? I mean, I looked at various provisions, and it just appeared to me that it used different phraseology in different situations, but that it wasn't necessarily consistent across the board.
Well, it does have an inherent logic to it, because in the existing use provision, the subdivisions A, B, and C lay out, here are the uses that are allowed within these specific river areas. So it makes sense for an existing use exemption to say, notwithstanding what's in here later on about what you can and can't do in a river area, you can continue an existing use. In other parts of the
But
act...
wouldn't it also make sense, I mean, the statute is much broader than that, and wouldn't it also make sense that it could apply to the broader context as well?
Not really, Judge, because it would effectively write the conflict provision out of the Rivers Act. The legislature understood very clearly that there is a distinction between private lands and public lands.
It would take the existing use provision away from the conflicts provision, but it doesn't mean that the conflicts provision wouldn't apply to other things.
Well, the conflicts provision is key to the decision in this case, because
Wait, slow down. Couldn't we rule in your favor without reaching that issue? Couldn't we simply say that it's irrational to conclude that opening up land to public snowmobiles would constitute an expansion and violate of the pre-existing use and avoid the conflict of laws question entirely?
Yes, absolutely. And that's one of the arguments that we make, that the fact that...
So it isn't necessary for this court to resolve that conflict of laws question and really, and going back to Judge Feinman's original question, declare the master plan similar to a legislative enactment. We could simply say that this was an irrational act, that adding the public to the snowmobile trail constitutes a simple expansion. Absolutely,
because the prior use was limited
and
to the...
then we really would be avoiding and limiting our decision to its immediate effects in this particular area.
Absolutely, Judge. And you know, this is absolutely an expansion of a use, because previously, snowmobiling was limited to the landowner, its contractors,
So then what
and to
wouldn't have
certain
been an
lessees.
expansion? Let's assume for one moment we disagree on the first part and we're focused on what Judge Fahey is focused on. What would not have constituted an expansion? What would have been a prior use within the meaning of the statute as applied here?
As applied to forest preserve lands, there cannot be
No,
an
as applied in this
existing
case on the
use.
facts of this case.
There isn't one, Judge. Our position is that a reading of the
There was
master
some discussion,
plan...
though, in the record about the pre-existing use that may have constituted more than the members of the club and the company that used to run the logging mill there. That there may have been, and some of those pre-existing use were characterized as trespassers in the dissent and just users in the majority. Are you familiar with that part?
I am, Judge. And that does not address anything that happened in the ownership in the 6 years between when the Nature Conservancy purchased the land and when the state purchased the land. That all comes out of the so-called Shackner report, which doesn't address at all what transpired on these lands for the 6 years immediately preceding its purchase by the state and its conversion into forest preserve lands. And that's a key point. With regard to existing use, there is no place for existing uses on forest preserve lands, and that's made clear by the fact that the master plan's dominant theme is that any uses that do not conform to the specific land classification must be discontinued within a certain period of time.
Thank you, Counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. May it please the Court, Laura Ettlinger for the state respondents. As the Court recognizes what's at issue in this appeal is the continued seasonal use of motor vehicles on a 1-mile segment of an existing road, Chain Lakes Road South.
But let me stop you. The argument is that this is just a little expansion, that this is a small use, that this isn't really much, and it's not something for the court to be concerned with. And see, the problem with that approach it's a twofold problem. First, it's sort of a reverse adverse possession argument that you can continue to turn land that's forever wild into land that's partially open to the public by improper uses that have taken place. That's one, and you can address these. I just want to clarify them for you. But the second one is a larger question, which is that this land in this forest preserve represents a jewel that is unique in American history, as we all of us here agree on that, and is frankly unique in the world. It helped create a worldwide environmental movement. It represents some of the finest decisions that have ever been made in New York State government. So the strictness with which we look at the state's actions here in that context make it more than a simple balancing act, and normally that's what we engage in here, but this is much more than that because of the nature of the land involved here. Setting aside the environmental situation that we're in right now, and just looking at this particular crown jewel, really, in New York State's long and illustrious history. So I don't think that we can simply say it's only a 1 mile piece of land. The point is that forever wild should mean forever wild. And even though the constitutional issue hasn't been brought up, whether or not an erosion of that principle by an action of either a state agency or by any court represents a direct threat to that, I think, unique and special treasure.
Well, I think what we're looking at there is the question of whether there's an expansion, and DEC
That's right, I agree with you about that.
rationally determined that there wouldn't be an expansion
So if it's
here.
rational, then what would be the numerical basis upon which you would say, or forget the numerical, any quantifiable basis that you're comfortable with to say that this would not constitute an expansion?
Because in the previous use by a major paper company, there was heavy commercial use and recreational use on this segment of the road 12 months out of the year. And there were many, many types of vehicles, including heavy trucks, 10-wheeler tractor trailers, excavation vehicles, regular use of motor vehicles and snowmobiles and ATVs, many types of vehicles 12 months out of the year.
Was that during the period the Conservancy had it? Own the property?
Yes, there still was continued use. First, I'd like to address a couple things about the abandonment, and I'll get back to the expansion.
Because I didn't think it was during the period that Conservancy had it.
Yes.
That use wasn't there.
While the Conservancy owned it, Finch Prine still had permission to do its commercial timbering operations through 2012. There were leases that continued the recreational use through September 2018. The Nature Conservancy itself had permission to use motor vehicles on the property through 2020. So the use did continue. There was no abandonment. And to the extent the record is not as fully developed on that issue as it might have been.
No, I understand that, but the question is, when you say it's open to the public, this 1 mile area of the road, and it's not going to be an expansion, isn't it your burden to show us how it will not be an expansion by pointing to some quantifiable report that's looked at similar situations?
Well, I think DEC could make a rational determination on this record, and I think the record does support it. It was going from 12-month-of-a-year use to limited seasonal use only for hunting access from October to the first week in December, about a 2-month period, and then only snowmobiles during the winter. And there were a change, as I was saying before, from all these different kinds of motor vehicles to only personal vehicles and snowmobiles. And that DEC on that record could rationally determine that there would not be an expansion of use. You had heavy commercial use on a regular basis 12 months out of the year. And because
is that an expansion or a different kind of use?
Either one.
Which raises a different issue,
yes.
Obviously.
The issue about whether there's an alteration, their only argument really, is that we're going from primarily private users who were there with the permission of the owner to members of the public. And that's simply not a legal, that criteria does not have.
You're also changing what kind of use, right? Because it's only, as you yourself saying, only the snowmobile.
only snowmobiles and personal vehicles to access for hunting. And that use is a diminishment
It's not like
of
the
use.
vehicles used for logging or the
No,
Conservancy
exactly.
used, right? So they're different in that way?
They're different in that
It's
way, but
altered
it's,
in that way?
well, it's not altered within the meaning of the
And
statute.
wasn't there already some evidence in this record that obviously if you're going to open it up to the public as opposed to the more limited individuals who had access, that it would be a greater use?
No, I don't think the record supports that it's a greater use.
There won't be a bigger tire print or a snowmobile
No,
print?
I think DEC rationally determined that there would not be in a bigger tire print, as you're saying.
Did they make that determination, or they weren't sure and they were going to take a wait-and-see approach?
No, I think going from 12 months out of the year with heavy commercial use and trucks and regular use on a regular
But didn't they
basis.
say there may very well be? And isn't that a wait-and-see approach which would
No,
perhaps
I
not
think-
make this a rational decision?
No, because I don't agree with that, Your Honor, respectfully, because the reference to a potential expansion only in snowmobile use, which is what that was talking about, was made in the SECRA determination, where the SECRA requires that the agency consider hypothetical and potential uses. But what we're talking about here for the expansion under the Rivers Act existing use exception is motor vehicle use, because the use that the statute talks about that would otherwise be prohibited if it were not for the existing use exception is motor vehicle use. And if you look at the motor vehicle use in the before situation, which was commercial use throughout the year and all different kinds of vehicles, and you look at the motor vehicle use that DEC is allowing, they're allowing only limited use in a limited time period.
Could we turn now to the question of the conflict?
Yeah.
Master plan and the
Yes.
statute? How do you overcome this conflict provision that
Because-
says the more restrictive provisions would apply?
We don't believe the conflicts provision comes into play here because of other language in both the Rivers Act and the master plan. First, as the court noted, the Rivers Act contains the existing use exception, clearly allows existing use exceptions that would otherwise be prohibited under the Rivers Act. And it says notwithstanding other provisions, anything else.
If we agree with the argument that notwithstanding refers just to that provision, not to the full title, what's your other argument?
Then the other arguments are that the Rivers Act recognizes that DEC's authority is exclusive to regulate river areas, and most importantly, the language in the master plan itself, which is at page 4 of the master plan, at Appellant's Appendix 574, which recognizes that DEC, quote, has the authority, independent of the master plan, to regulate uses of waters and uses of wild, scenic, and recreational rivers.
But isn't that merely recognizing the existing authority?
It's
It's
recognized.
not, otherwise, what's the point of the master plan? Your position means they could completely ignore, no one needs to follow it.
No, because the only exception here is the very limited exception.
No, but the logical conclusion of this argument is that the master plan is completely nullified and has no import.
No, I don't think so. I think what it's saying is that when there's something in the master plan that addresses also what would be in the Rivers Act, DEC has primary authority under the Rivers Act.
What is the legal force of the master plan?
Well, it has been held by lower courts to have the force and effect of legislation. That's the language that's been used. It's clearly not an actual law that has been enacted by the legislature, but it has been held to have the force and effect of legislation.
No, but there was a statutory amendment post the master plan, so indeed, by implication, the legislature has recognized and adopted this plan.
Well, the legislature has referenced the master plan in Section 816 of the executive law.
And says there has to be compliance with the master plan.
And the important thing is that the APA is tasked with that responsibility to determine whether DEC's proposal here was consistent with the master plan, and the APA, which drafted
But if you have
the
another
master plan.
statute,
I'm
that
sorry?
if you have another statute that says something else, an agency's determination cannot in any way overcome the statutory mandate, right? So I'm still not understanding the argument about the conflicts provision that is in a statute.
Well, there is no conflict, is our position, because
If we disagree with you, If we disagree with
If you disagree and find that there is a conflict here and that the master plan is a law within the meaning of the conflicts provision, that is the opposite of our argument,
Let me
which
just,
results in what outcome?
a reversal here.
Thank you.
let me just go back to what we were talking about before. So the way I understand the petitioner's argument is that they argue that there will be an increase in volume, and that's the key analysis that needs to take place. Whatever the type of vehicle is, there will clearly be more of them as a result of this decision. So the way I understand your burden there is to say, no, your burden isn't, and you can correct me if you think I'm wrong, tell me why you think I'm wrong. Isn't it your burden to say that no, there will not be an expansion in volume, and this is what we point to show that there will not be an expansion in volume? There's a large amount of anecdotal evidence in what you refer to the Schachner report, which is a report that was basically from 19 different interviews that the law firm from Glen Falls did, which is in the record, and the DEC can certainly draw on that. But beyond that, is there any numerical basis for that decision?
Well, there isn't a numerical basis, and there wouldn't ordinarily be one in this kind of case, because you're talking about property that was privately owned. No one was keeping track of the number of vehicles that were transported on.
I grant you that. So what would be then the basis for that rational decision, if it was rational?
The question is whether it was rational, and the answer is that they were going from 12 months of heavy use commercially and recreationally to a limited period of use and a limited number of limited types of vehicles. And on this record, the question is, on that record, could DEC rationally determine that there wouldn't be an expansion? And we believe DEC made that
I
determination.
guess, you know what I think of? There's too many people everywhere. Wherever you go, and we all have this experience, I think, wherever you go on a tourist trip, anywhere you go, it's just immensely crowded. You can't walk through Venice at 4 o'clock in the afternoon if someone goes on the trip of a lifetime, because it's overwhelmed with people. The Joshua Tree has practically been destroyed and had to be isolated because so many people come to everything. The Adirondacks is the same way. And is it rational to conclude that if you open up a section like this to the public for snowmobiling, that you will be overwhelmed with volume? Isn't that a much more rational decision?
But the question isn't how many users will there be on a particular day. I actually have two answers, if I may.
Okay, go ahead. Yeah.
The question isn't whether there will be too many visitors on a single day. The question is, was the use beforehand going to be expanded from the use that's allowed now? So even if there are more on a certain day, the overall question under the Rivers Act, which looks to motor vehicle use, is whether that motor vehicle use before, for example, on an annual basis, will be expanded beyond what it was beforehand. And I think it is also important that DEC will be monitoring, because DEC has administrative mechanisms.
Let me just jump in a little bit. The problem with that argument is you yourself have said is that you don't know exactly what Fitch Prune, is that the name of the company? Yeah, you don't know what their volume of use was. Let me finish.
I'm sorry.
So if you don't know what their volume of use is, and you can't predict the public volume of use, except any rational person would think it's going to increase during the period that it's open, then how can you make this call? What's the reasonable basis upon which you can rely on your decision here?
Well, we believe the reasonable basis is the record here that shows there was 12-month regular use. If you read the Schachner report, it's very clear that cars and trucks and ATVs and all types of vehicles were going through this area on a very regular basis, 12 months out of the year.
That includes the 6 years the Conservancy? Is that true for those 6 years?
There was still continued use, and if this case comes down to...
No, but I'm asking,
Well,
the record has to say something according to you, right?
Well, that issue wasn't raised by petitioners, so it's not a preserved issue in this case, which is why, to the extent the record...
I mean, how far back one goes?
Well, the question under the Rivers Act is whether it was a continuing use at the time the river was designated, which is 1972.
Right,
And
so
the
then don't we
record
look at
very
that moment as opposed to
Yes, if you
70
do,
years prior?
Yes, you look at 1972, and there was an
So what's the
existing-
evidence on that moment?
in the Schachner report.
Yes, well, what is it?
That there was regular daily use of this by trucks, by cars, by ATVs, and that
By the company and the conservancy.
by the company and by the regular, consistent recreational use by the individuals who had permission to be there under leases with Finch Prime. Finch leased large tracts of their property to recreational clubs and individuals. There were camps in this very location. There was a farmhouse, outer buildings, a garage. It was clearly regularly used.
Chief, may I just follow up? Just one question and a basic one, and there may be an easy answer to this, but the Rivers Act applies to private and public land.
Yes.
If it falls within the definitions and all. So going back to the notwithstanding clause and the interpretation given to it by your adversary, under that view that the notwithstanding clause only applies to this internal section, and then the other section says no motor vehicles, would the existing use itself by the private entity violate the Rivers Act?
Well, an existing use does violate, by a private user or on private land, does violate the Rivers Act unless DEC or the APA, if it's in the state park and it's private land, allows that use to
I
continue.
think you're missing, my question would be, is any use of a motorized vehicle on private land that falls within this category under the Rivers Act would be a violation, despite the fact that it was existing or not?
No, it could be continued, but it's up to DEC.
Not under his interpretation.
Oh, under his interpretation, right. Yes,
It
I
would
agree with
always be a violation.
It
So
would always
any
be, it
land-
would write the exception out of the statute.
So when they put this land within the parameters of the Rivers Act, at least this classification, all of that would have been prohibited use, and it would have been a compensation or takings issue at that point.
Yes, yes, exactly. I'm sorry, I didn't understand.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Thank you. With respect to the claim that these lands were subject to 12 months of heavy industrial use, that's simply not the case. Once the Nature Conservancy purchased the land from Finch Prine, there was a drastic reduction in the forest management activities that took place on that land, and there was a different ethos being applied to the management of those lands, because the Nature Conservancy's ultimate goal was to do exactly as it did, which was to sell those lands to the state of New York in order for them to be added to the state's forest preserve.
But is it your position that the existing use here, the use of snowmobiles on this land, was a violation of the Rivers Act?
No, it's not. Our position is that the existing use provision simply doesn't apply to forest preserve lands. Once these lands became part of the New York State Forest Preserve,
That's a
existing
different
uses
argument, I think.
just don't.
Because I think in that language, though, it references both entities that have jurisdiction over the lands. One is the one that controls private, one is public. So I don't think you can read it to support that. But I thought that your point was that the no motorized vehicle provision trumps the notwithstanding.
It does, because first of all, because the notwithstanding language applies only to the provisions within that particular section of the Rivers Act. And that section lays out, here are the uses that are allowable and prohibited in these specific river areas. And
So when that act was passed and they were using snowmobiles on this land, although it was private, aren't they violating the act under that view?
yes, they would be.
And anyone else who's doing that right now on private land within this category under the Rivers Act, if we went with your interpretation, would be violating the Rivers Act.
Well, again, I think it depends on the facts, Your Honor, because it's not a clear-cut question when you're talking about private lands, because the existing use provision does apply to private lands. So if snowmobiling had been occurring within that wild river area by Finch Prine.
But that seems inconsistent with your point that that doesn't matter because it's trumped the notwithstanding provision anyway by the no motorized vehicles provision.
Because it's now state land. Because the conflicts provision applies to river areas that are located on state lands. So in other words, forest preserve located in the Adirondack Park, forest preserve located in the Catskill Park. The legislature, number one, in that provision, specifically acknowledge that river areas that are located on forest preserve lands are subject to a suite of regulatory controls. Those regulatory controls and restrictions are imposed not only by the Rivers Act, but by the Master Plan and by Article 14 of the New York State Constitution, the Forever Wild Clause. And the legislature then went a step further and said, in the event that there's an inconsistency or a conflict between these multiple regulatory schemes that apply on forest preserve lands, the more restrictive one is to apply. And that's entirely consistent with the overarching purpose of both the Master Plan and the Rivers Act, both of which are geared towards protecting and preserving these incredibly unique natural areas.
Thank you, counsel.
Thank you.